By the time the fire truck backed down my driveway and realized it could not turn around, the HOA president was still insisting the concrete barricades were purely decorative. "Ma'am," the fire captain said slowly, "your decoration is blocking the only bridge to this man's house." "It is private community infrastructure," sniffed Paula Kensington, HOA president of Willow Bend Landing. "He can park outside the gate and walk. We have standards." I stood on the far side of the little creek, arms crossed, next to my very stranded Toyota, my mailbox, and my entire house, which now may as well have been on an island called Screw You, Miles. The 3 waist-high concrete planters she had installed across the bridge, each one filled with identical ornamental grasses, formed a perfect barricade. Beautiful, symmetrical, completely impassable. The sheriff eyed the setup. "Let me get this straight. You blocked the only access road to his property?" "It is an HOA-controlled common bridge," Paula said, with that tight little smile people get when they are wrong but armed with a binder. The board voted. He violated aesthetic guidelines. On the bridge, the tow truck driver scratched his head. "So, you want me to drive over the creek?" "No one is driving over anything," Paula snapped. "This is our bridge." The fire captain turned to me. "Mr. Hanley, did you approve this?" I smiled. "Nope. But the judge I am seeing on Thursday is going to love it. My name is Miles Hanley, and all I wanted from life was a quiet house at the edge of a cul-de-sac, a small workshop in the garage, and reliable Wi-Fi. I got 2 out of 3. I live, or at least theoretically live, in Willow Bend Landing, a master-planned HOA neighborhood built around a little creek and a decorative pond. My house sits on the far side of that creek, reached by a single 1-lane concrete bridge the developer put in years ago. The listing called it charming private access. The county called it a legal ingress/egress. I called it the reason my Amazon packages do not get stolen. Willow Bend Landing is the sort of place where the grass is always exactly 3 inches high, the mailboxes all match, and the biggest local controversy is whether seasonal wreaths count as year-round decorative elements. Enter Paula Kensington. Paula is the kind of HOA president who treats the subdivision like a small, poorly funded monarchy. Perfect silver bob, pastel cardigans, pearls. She has a laminated copy of the covenants in her car. She says we when she means the board, even though the board is just her and 2 people who seem to exist solely to nod. I had lived there for a year with only minor skirmishes. One warning about my trash can being visible from the street for more than 12 hours, one strongly worded letter about my non-approved flag. It was a support local libraries flag, so clearly dangerous. Things escalated the week I repainted the bridge railings. They had been peeling and rusting, so I did the responsible homeowner thing. Wire brushed, primed, and painted them a conservative dark charcoal. It looked classy. It matched my shutters. It did not match whatever was happening in Paula's soul. 3 days later, I got the email. Subject line, urgent. Unauthorized modification of common structure. Miles, you have illegally altered the appearance of the Willow Bend Landing pedestrian/vehicular bridge, which is under HOA control as a common element. This is a serious violation. The board will be discussing appropriate remedies, including removal of your unauthorized changes. Signed, Paula Kensington, HOA President. I thought appropriate remedies meant annoying letters. I was wrong. The harassment campaign started quietly, like mold behind drywall. First came the notices. Unauthorized alteration of common property, the paint. Encroachment on HOA easement, my potted plants at the driveway end of the bridge. Improper use of bridge structure, because my contractor parked his truck there for 20 minutes. Each notice carried a daily accruing fine number that seemed less like governance and more like a ransom demand. I wrote back, attaching the plat map and my closing documents. Hi Paula, per county records, the bridge is the legal access to my parcel and part of the recorded easement. I am responsible for maintenance and the county fire marshal signed off on it. Happy to share documents. Cheers, Miles. No response. Instead, she started weaponizing the architecture committee, also just her. One afternoon, I got home to find bright orange cones placed at each end of the bridge and a laminated sign. HOA notice. Temporary closure. Bridge under review for safety and aesthetic compliance. Do not cross. HOA not responsible for damage or injury. I moved the cones and drove over. A Ring camera across the creek captured Paula marching out later, putting the cones back, muttering about non-compliant members. Neighbors started mentioning weird comments from Paula at the pool. Miles Bridge might be condemned soon. We are looking at revoking his access to common areas. He has put everyone at risk with his alterations. Alterations equals paint. Then came the spy photos. Registered mail, an envelope with glossy 8.5 by 11 printouts of my Honda parked halfway on the bridge. A note, proof of misuse and overloading. This structure was meant for light vehicles only. You are endangering the community. My Honda Civic is many things. A heavy vehicle is not one of them. At this point I stopped emailing and started documenting. Every letter. Every cone. Every time I saw Paula standing at the far end of the bridge taking photos like my life was a crime scene. Then she overplayed her hand. One Monday, I left for groceries. When I came back, there were 3 concrete planters, giant ones, arranged across the bridge like chess pieces, each filled with tall grasses. Behind them, a brand-new, waist-high metal gate with a lock. A fresh sign, Willowbend Landing HOA. Bridge closed to vehicular traffic. Pedestrian access only. By order of the board. My house, my car, my garage, my entire life now required a hike and a hand-carried load for groceries. I called Paula. She answered on the second ring, syrupy sweet. Miles, this is a safety measure. The bridge was never intended for regular vehicle traffic. We are protecting the community's liability. You cannot block my only access, I said. That is illegal. Then park on the street and walk, she chirped. Plenty of people in Europe do it. I hung up, called the county, and within an hour had talked to zoning, public safety, and the fire marshal. All 3 said some version of, wait, they blocked your only access? They did what? That is how we ended up with a fire truck, a sheriff, and a very offended tow guy all staring at Paula's decorative barricade. And that is when someone from the county said the magic words. You may want to get an attorney. This is bad. For them. The turning point arrived in the form of a very bored, very sharp real estate attorney named Claire Mooney. I dumped 3 folders on her desk, my deed, the plat map, every HOA letter, and about 50 color photos of Paula's concrete fortress. Claire flipped through them, eyebrows climbing. They blocked the ingress and egress to your property. Without a court order. Without county approval. And then told you to hike your groceries across a footbridge. Yep. And they are fining you for using the bridge that serves your recorded easement. Also yep. Claire leaned back. Okay. I love this for us. She explained things I had never heard of, easement interference, constructive eviction, breach of fiduciary duty, nuisance, and my new favorite phrase, seeking injunctive relief with attorney's fees. She also made a call to the county fire marshal, who faxed, because of course it was fax, a letter stating that the blockage created an unacceptable limitation on emergency access in violation of fire code. Within a week, Claire had filed a lawsuit against Willowbend Landing Homeowners Association, the individual board members, and, by name, Paula Kensington, president. The suit asked the court to order the immediate removal of any obstruction from the bridge, bar the HOA from interfering with my easement, award damages and attorney's fees, and potentially appoint a receiver to take control of the HOA if mismanagement was proved. Paula responded the only way she knew how, with a 12-page community update email full of lies. She claimed I had illegally modified a fragile historical structure. It was built in 2012. The county had expressed serious concerns. The county had expressed serious concerns about her. The bridge closure was temporary pending safety review. It was permanent unless a judge disagreed. Unfortunately for Paula, a couple of things happened at the same time. A neighbor with a brother in the clerk's office pulled the public court filing and posted screenshots in the neighborhood Facebook group. The local small-town drama Facebook page picked it up and summarized it as, HOA allegedly blocks dude's only bridge. Dude sues. Fire marshal says absolutely not. Suddenly, half the neighborhood realized, wait, If the HOA can block his access, what can they do to ours? Support shifted. Quietly at first. Then loudly. By the time our first court hearing rolled around, I walked into the courtroom with Claire on my left and 3 neighbors on my right. Paula walked in alone, clutching a binder like a life jacket, her HOA lawyer trailing behind her with the resigned look of a man who knows his client is about to talk too much. The power shifted in a single question from the judge. The judge was an older woman named Judge Herrera, with reading glasses halfway down her nose and the facial expression of someone who had seen every possible neighborhood feud and was no longer impressed. After Claire laid out our case, easement, county fire code, photos of barricades, the fire marshal's letter, Herrera turned to the HOA lawyer. "Counsel," she said, "why did your client block the only access to the plaintiff's home?" The HOA lawyer opened his mouth. Paula beat him to it. "Your Honor," she began, standing up uninvited, "this bridge is community property. It was never intended for heavy vehicles. Mr. Hanley has repeatedly abused that privilege by parking work trucks, painting the railings without approval, and—" The judge held up a hand. "Miss Kensington, you have an attorney. I will hear from him first." Paula sat, cheeks flaming. Her attorney cleared his throat. "Your Honor, the board believed they were acting within their authority to protect common property and community safety. Did they have a structural engineer's report?" The judge asked. "Not formally, no." "Did they seek county approval before altering a bridge that provides the only ingress and egress to a residence?" "No, Your Honor, but—" "Did they receive any communication from the fire marshal authorizing, recommending, or even suggesting closure?" "No, Your Honor." The judge turned to me. "Mr. Hanley, how long was vehicle access blocked?" 6 weeks, Your Honor." "And during that time, how did you access your home?" "Parked across the creek and walked. Carried everything in by hand. No deliveries could reach me. I had to cancel a refrigerator replacement because the truck could not cross. And emergency services would have had to do the same." Claire slid a photo across. The fire truck backed up at the bridge, the barricades front and center. The judge studied it, then looked slowly back at Paula. "Miss Kensington, stand up, please." Paula did, clinging to her binder like it might sprout a legal degree. "Did you personally approve or direct the placement of these barricades?" "I coordinated the installation on behalf of the board, yes." "Did you know this bridge was the only road access to Mr. Hanley's home?" Her jaw flexed. "Technically, yes, but he could always—" "Yes or no?" "Yes." "And you still ordered it blocked?" "We believed he could park and walk. It is a very short distance, and European." The judge frowned. "This is not Europe, Miss Kensington. This is a residential home in this county, and you intentionally obstructed his legal access without authority. That is not a policy dispute. That is serious." The courtroom went quiet enough to hear the HVAC kick on. The judge turned to the HOA attorney. "Counsel, I am inclined to grant immediate injunctive relief. Your client will remove all barricades by end of day tomorrow and cease any interference with Mr. Hanley's easement pending full trial. I am also very interested in hearing arguments later on damages and attorney's fees." Attorney nodded, already defeated. "Understood, Your Honor." Then came the kicker. The judge looked back at Paula. "And based on what I am hearing about unilateral decisions and disregard for safety, I am also considering whether this board has breached its fiduciary duty to the association. We may be discussing outside management or even a receiver." Paula's eyes widened. "A receiver?" The judge's gaze sharpened. "That is where someone else takes over because you have made too big a mess." Power had officially exited the HOA clubhouse and relocated to courtroom 3B. The climactic moment came with a 27-page court order that read like a roast. Weeks later, after more hearings, more documents, and one truly disastrous attempt by Paula to argue that aesthetics are a form of safety, Judge Herrera issued her final ruling. Claire emailed me a PDF with the subject line, "Enjoy." Highlights, as translated into normal human. "The bridge is part of a recorded easement that guarantees my vehicle access. The HOA had no authority to block it, gate it, or treat it like a decoration. The board acted in willful and reckless disregard of safety and owner rights. The HOA is permanently enjoined from interfering with my access, full stop. The HOA must pay all my attorney's fees, statutory damages for interference with easement, and a civil penalty related to emergency access obstruction. Due to mismanagement, the HOA is placed under mandatory professional management for at least 3 years. And then the cherry on top. The court further finds that Miss Kensington, in her capacity as president, acted ultra vires and in bad faith. The association shall remove her from any position of authority within 30 days, and she shall be barred from holding any officer position for the duration of this management period. In English, Paula was legally dethroned. The day the management company's truck pulled up was a festival. A guy in a polo shirt with a clipboard introduced himself as Tom, the new property manager. Our job, he said to a small crowd of neighbors, is to keep the grass mowed, the budget balanced, and nobody's bridge blocked. We are not here to run a dictatorship. He supervised as workers removed the planters and gate from my bridge. When they lifted the last one off with a mini skid steer, people actually clapped. From her porch, Paula watched, arms folded. Her name plaque, HOA President, had already been taken down from the clubhouse door. Tom walked over to me. "We are also issuing a letter of apology from the association," he said. "Our attorney is strongly recommending it." A week later, every mailbox in Willowbend Landing got a letter on HOA letterhead. "We regret the actions taken by the previous board that interfered with a homeowner's property access and did not reflect the values or responsibilities of the association." Neighbors read it like it was a scandal novel. My favorite part of the court order came later, though. The judge required the HOA to hold a mandatory community meeting where the new management would explain owner rights, easements, and what the HOA definitely cannot do. Paula sat in the second row, forced to listen as Tom used my bridge as a PowerPoint case study titled, "What Happens When an HOA Oversteps?" Don't do this. On the slide behind him was a photo of the barricaded bridge with a huge red X over it. I nearly framed it. Life in Willowbend Landing is quieter now. The grass is still 3 inches high. The mailboxes still match. But the vibe has changed from Stepford cult to mildly over-organized suburb, which is frankly a massive improvement. My bridge is open, freshly painted, still charcoal, with a small, boring sign the management company insisted on: authorized vehicle access only. I can live with authorized if the authorizer is not Paula. The HOA now has a budget that actual adults oversee, a rule that any major action affecting access or safety must go through the county, and a new board elected by people who do not think concrete planters are weapons. As for Paula, the punishment is exactly calibrated to her personality. She is still here, but she has no power. Court order says she cannot hold office for at least 3 years. The management company made it clear they do not want informal input either. If she sends one more mass email, they told her, they will route communications through them only. At community events, she hovers on the edges, watching Tom calmly explain things she used to bark. "We cannot fine you for the color of your welcome mat. No, we cannot shut down your driveway because your car offends us. And absolutely not, we cannot touch anyone's easement." She tried to restart her reign in a smaller form, starting a beautification committee. No one signed up. The only volunteer was her husband, and even he bailed after the first flyer got laughed at in the group chat. The financial pain was real, too. The court-ordered fees and damages hit the HOA reserves hard. Special assessment time. At the annual meeting, Tom laid it out. "We have to cover the legal costs from the bridge litigation. That is going to be a one-time assessment of." Every head in the room turned, slowly, toward Paula. She stared straight ahead, jaw clenched, as her own neighbors realized they were writing checks because she could not leave my bridge alone. Nobody said her name out loud. They did not have to. If there is a moral here, it is something like, an HOA can tell you how tall your fence should be. It cannot cut off your home like it is banishing you to a medieval island. Or, even shorter, do not build a power trip on someone else's bridge. A judge might just blow yours up instead. Because in the end, I did not just get my access back. The only thing really closed for safety in Willowbend Landing now is Paula's career as a suburban tyrant.